I see Judge Aviva, I see Judge Stein. We'll just have to make him into a co-host. All right, it is 12 o'clock. Good afternoon, everyone, and thank you for appearing, judges, counselors, and members of the Decalogue. My name is Judge Colleen Reardon Daly, and I currently sit in the Rolling Meadows Courthouse, courtroom 206, which is a civil non-jury courtroom. Some of the cases I hear definitely are high volume cases, specifically the consumer debt call and the eviction call. This 1 hour CLE entitled Best Practices for Attorneys Appearing in High Volume Court Calls is presented in a panel type setting where I will serve as the moderator and pose questions to the judges and practicing attorneys who are on the panel, with our learning objective centered on providing some best practices, professionalism perspective, and practical strategies for attorneys who appear in these high volume calls. We do recognize that there are various types of high volume calls that attorneys appear on. To name a few: consumer debt calls, eviction calls, state's attorney child support calls, order of protection calls, mortgage foreclosure calls, post-judgment collection proceedings, and pretrial matters for the civil jury section, room 1501 at the Daly Center. Today, we only focus on a few due to time restraints, but hope to provide some helpful points to the attorneys who we are honored to have appear in front of us. Towards the end of the hour, we will have a few minutes for some questions that you as the audience may have. Thank you for the 63 plus attorneys and individuals who appeared and signed up for this CLE. All right, first, I'm going to give you the biographical background for Judge Fred Bates. Judge Bates is the supervising judge of the Civil Division in the 6th Municipal District in Markham. Prior to being elected as an associate judge in 2020, he was appointed as a Cook County Circuit Judge by the Illinois Supreme Court in 2015, and then reappointed in 2016 and 2018. Since becoming a judge in 2015, Judge Bates has served as a mentor in the Illinois Supreme Court's new judge mentoring program for the Circuit Court, as a peer mentor in the Illinois Supreme Court's Judicial Peer Mentoring Program for the Circuit Court of Cook County, and as an instructor in the Illinois Judicial College's biannual education conference, as a member of the Illinois Judicial College's Committee on Judicial Education and their Advanced Judicial Academy. Prior to becoming a circuit court judge, Judge Bates served as an administrative law judge and hearing officer for over 15 years and studied extensively through the National Judicial College. His legal employment background prior to joining the administrative law judiciary included clerking for the United States Court of Appeals, being an associate at a major Chicago firm, serving as an equity partner at 2 large firms, and being president of the first minority-owned corporate law office in the country, where all the partners had been partners at major corporate firms. Judge Yolanda Sayer is a judge on the Circuit Court of Cook County 1st Municipal District Housing Section, where she hears building code violation cases, including demolition, conservation, and other cases centered around life safety. Judge Sayer was appointed to the bench by the Illinois Supreme Court on February 2nd of 2024. Her assignments have included a brief stint in the Traffic Division, a civil room in the 6th Municipal District and the Domestic Violence Section. Prior to her appointment, Judge Sayer was legal counsel for the Illinois State Police, a position to which she was named in 2021. Before that, she served as an attorney for the Chicago Police Department and was assigned to the Office of Constitutional Policing and Reform. During that period, Judge Sayer served as the city's corporate and expert witness on issues related to the 4th, 5th, and 6th constitutional amendments and training. Over the course of her career, she also worked in private practice, including being of counsel at Stein Law Offices, where she focused on commercial litigation. Judge Sayer supplemented her legal work with assignments as an administrative law judge and as a contract prosecutor for the Illinois Secretary of State. Judge Alon Stein took the bench on December 2nd of 2024. After serving briefly in the traffic division, he was assigned to courtroom 1501 of the 1st Municipal District of the Circuit Court of Cook County, where he also works closely with the Arbitration Center of the Circuit Court of Cook County. Prior to becoming a judge, Judge Stein was in private practice as a litigator and trial attorney. He tried many cases and argued before the Supreme Courts in both Wisconsin and Indiana. He received his undergraduate degree cum laude from the University of Illinois at Chicago and his law degree from the University of Wisconsin Law School, so he's a Badger, like me, where he was managing editor of the Wisconsin Law Review. Judge Stein is admitted in Illinois, Wisconsin, and Arizona. He regularly covers the non-jury trial room, room 1110 at the Daly Center, as well as room 1501. Judge James Allegretti is a circuit court judge elected in 2016 and since 2018 presides in the 2nd Municipal District, room 204. He hears both bench and jury trials involving torts, contracts, eviction, post-judgment matters, administrative review, detinue, and replevin. Before ascending to the bench, he spent almost 40 years practicing in the areas of personal injury, workers' compensation, and criminal law. Prior to joining the Cole Law Firm in 2025, attorney Jade Dido was a legal assistant for a high-volume real estate firm in Chicago for a period of 4 years, where she specialized in preparing commercial property valuations and appeals. Attorney Dido focuses on consumer litigation as one of the Cone Law Firm's Illinois attorneys. Attorney David E. Gordon is a senior attorney at Blitten Gaines PC. He graduated from honors with the University of Illinois Champaign-Urbana with a degree in accounting and later received his law degree magna cum laude from that same institution. Mr. Gordon's practice focuses on collections, providing comprehensive representation to credit card issuers, auto financing companies, unsecured lenders, law offices, public utilities, and debt purchasers. He believes that everyone involved in the collection process benefits from the ethical collection of debt. He represents each of his clients, large or small, with one common goal: to leverage his experience and expertise in achieving consistent recovery results. For more than 3 decades, he has worked with clients in all phases of commercial litigation and debt recovery, from pre-legal action through the state and federal appellate processes. He has a keen understanding of applicable pre-judgment and judgment garnishment statutes. He has also been involved in bankruptcy proceedings in order to protect creditors' rights. His thorough knowledge of procedural rules and state collection laws helps him attain positive outcomes for his clients while complying with all the requirements that the law demands. All right, now we're going to move on to questions for our esteemed panel. Judge Stein, what type of cases are heard in courtroom 1501 at the Daly Center, and is this a high-volume courtroom?
First of all, good afternoon to everybody. Thank you for being here. Courtroom 1501 is part of the 1st Municipal Division. It is the civil motion section and the arbitration calendar for personal injury cases. Think of the billboard attorneys that you see on the highway and a wreck need a check, call 222-2222. That's the type of cases we have here. Defendants are usually represented by attorneys hired by insurance companies. I manage the arbitration call in 1501. A plaintiff is demanding $50,000 or less, and someone has filed a jury demand. I hear three busy calls in the morning: 9 o'clock, 10 o'clock, 11 o'clock. There are usually 25 to 35 cases on each of the three court calls. At these court calls, I hear mostly arguments on motions to compel discovery, motions for alternative service, motions to continue arbitrations, motions to extend other deadlines. We set arbitration dates and all discovery closure deadlines. I hear initial presentment of dispositive motions, set oral argument dates. I schedule pretrial settlement conferences. I do that in the morning. In the afternoon, I hear oral arguments on contested hearings, mostly motions for summary judgments and motions to dismiss. I usually hear about 2 to 3 oral arguments for dispositive motions at 1:30 and 2 to 3 oral arguments for dispositive motions at 2 o'clock. I also conduct pretrial settlement conferences at the conclusion of my 1:30 or 2 o'clock oral arguments.
Thank you. Obviously, a very busy and expansive courtroom, Judge Stein. Judge Stein, what have you done specifically to make courtroom 1501 run more efficiently for the attorneys and litigants who appear in front of you?
Well, for starters, in the last day, I just drafted up a new standing order for the room, and it's now available, and I think we have that in the materials. So
We do, just for everyone, in the materials, there are various courtroom orders of the judges that are here, along with the ERP order.
Well, in addition to that, my first couple of weeks as a judge assigned to courtroom 1501, I spent my free time observing the judges in the law division motion section. This room is very similar to the law division motion section and also the law division commercial calendar section. Can you hear me, everybody?
Yeah.
All right, good. All right,
Perfectly well.
All right. Before becoming a judge, I practiced mostly in the law division's commercial calendar, and I wanted to bring some of those practices to First Municipal because I found that the commercial calendar and the law division motion sections run pretty effectively, and I didn't want to reinvent the wheel. I'm also very prepared. I prep the morning calls a week in advance. I spend a good chunk of my Sunday mornings preparing for the oral arguments on the dispositive motions and strategizing for ways to facilitate settlements for my pretrial settlement conferences.
Thank you. Judge Stein, what materials did you include today that you think will be very helpful to the attorneys who regularly appear in front of you?
My new standing order and I have a 36-page outline as to how to practice in the courtroom, and I have like an abridged version of that as well that I sent.
And so in those orders, they present the main requirements for attorneys and litigants appearing in 1501. Is that correct?
Well, here's what I typically want. I want the lawyers to be prepared. If I ask an attorney a question, I want answers. I don't want to hear, I'm just covering for the partner. I don't know anything about the case, which happens quite a bit. When you file motions at 9 o'clock, 10 o'clock, or 11 o'clock motions, of course, I want a proposed order as part of the motion so I can write on the proposed order my additional rulings, which become a final order. I don't require the attorneys to email a final order to the clerk by the afternoon. I modify it and I sign and stamp it, and that's the order. If you don't submit a proposed order, I will strike your motion. I want courtesy copies 7 days before the oral arguments in the afternoon. I don't need courtesy copies of the 9 o'clock, 10 o'clock, and 11 o'clock motions, only the briefs for the oral arguments. Just be prepared. That's pretty much it.
Thank you, counsel. All right, Judge Bates, where do you sit and what type of cases do you preside over?
I sit in the 6th Municipal District. I preside over, I preside over a myriad of cases, to be frank with you. I hear eviction cases where, as a triage courtroom for the most part. I hear debt cases, post-judgment collection cases. A picture is worth 1,000 words, so I'm going to screen share what I do. Mondays and Fridays, I try the cases. Tuesdays are Blit and Gaines Day in the morning. There are eviction cases in the afternoon. Wednesday are the consumer debt and post-judgment calls for all other law firms. You'll see the case caps are highlighted there. Thursdays are my self-represented litigants date. I want the attorneys to know that I have told the clerk repeatedly, if a pro se defendant has a case with a law firm, their motion should be set on the law firm's date, not the pro se date. Sometimes it happens, sometimes it doesn't. The orders are due 48 hours in advance. If they are set on the wrong date, as you see down there, I don't hear it. I have a practice in my courtroom where I tell people their orders are due 48 hours in advance, and if they email my court coordinator, which I do have, if they email my court coordinator, they will get an auto response that tells them the dates we are giving in the future so that they can put the dates in their orders that they send me. And I'm going to screen share that as well. So for example, if you email my court coordinator, you get an auto response. It tells you all orders must be submitted 48 hours in advance for the consumer debt and post-judgment calls. And it tells you today, for example, we gave July 29th as the date. Usually it's not that far out, but because I am on vacation for 2 weeks in the next 6, it is. But you'll see when we get back in August, it's back to about a month. They're usually a month out.
Judge Bates, you mentioned receiving the orders in advance. Why is it so important, especially in a high volume call where, and I know that you prep your call many days in advance and from the times we've talked on the weekends even, why is it so important that the orders, even if they're not completely filled out with the understanding people resolve cases right before, why is it so important that they be sent in advance of the call, even if there is not certainty about what will happen?
So somebody asked a question that I actually want to answer. Lynn,
Please.
you
And I
practice
think,
you
yes.
practice in my courtroom a lot. So the answer to the question is, what if we want an alias that's more days out? My standing order says if you want a date that is different than is the one you get in the auto response, please email my court coordinator. Why do we do that? So my courtroom is the highest volume courtroom outside of the Daily Center in the county, frankly. And I'm going to screen share my calendar for today as an example. I was supposed to have 200 cases on my call. I had 274. Not really, because we had 70 add-ons that we received the orders 48 hours in advance. That took us to 340. We had 70 more orders that we got yesterday. I refuse to hear those cases. I refuse to hear those cases because nobody's prepped. Nobody knows what it's about. My standing order is very, very clear, and that's why it's the first paragraph of my auto response from my court coordinator. You must submit 48 hours in advance, because it's the only way we can be prepared to know what's coming. And I hated being in the Circuit Court of Cook County as a practitioner because the judges were never ready. We have a whole new judiciary today. We're prepared.
And counsel, your high volume call, is it in person, remote, or hybrid? Judge Bates, do you have a hybrid courtroom where attorneys can appear either way, or parties?
I would say 95% of the attorneys are on Zoom in my courtroom. I have 2 or 3 attorneys who come in person.
And that's why the orders being sent in electronically in advance is so important.
Right.
All right. So Judge Bates, another question for you. And obviously there could be a few CLEs where the early resolution program is discussed, and time does not permit us to do this. However, the early resolution program, known as ERP, which is very involved in the eviction and the consumer debt call. Can you briefly describe what it is and what its essential role in your daily proceedings in the 6th district is?
I know the focus this afternoon is mostly on consumer debt, but I'm going to start with the evictions. In my opening statement, I tell people I'm a triage courtroom. If it's their first time here, they will be referred to the early resolution program where they will get free legal assistance or rental assistance. They have to be on Zoom because those people are downtown. We have 10 computers in the building. I send them to the basement. They log in. They go in a breakout room with ERP. On the consumer debt side, when I give my opening statement, I tell them, because the case is high volume and moves lightning quick, as Ms. Mason or Dave will tell you, it moves lightning quick. I ask, when you unmute yourself, if it's your first time here, please tell me this is my first time here. Right away, somebody types ERP in front of their name, pulls them to the breakout room. They tell them your next court date's going to be July 29th at 9 o'clock. And so that's how it works. They are remarkable in assisting me move 300 or 400 cases off my call in an hour.
And you mentioned finding out when someone has never been in front of you before. So do you encourage attorneys to ask questions about your procedures and even to appear on your call or stay after your call so they can ask you these questions?
When I took this room over from Judge Sayre, who had it for about 2 minutes, I decided that I was significantly more senior than she was when she had this room, that we needed to structurally change the room, which was something she had not been authorized to do. I involved the attorneys, and I still involve the attorneys. I asked questions today because of the commercial that I need to give before we go off of here. So yes, I encourage the attorneys to stay on periodically at the end of the call to give me their feedback, particularly Mohammed Zain from Blitton Gaines and the folks from Cone, who are probably the 2 highest volumes in my courtroom,
Yes.
who I talk to from time to time just to make certain. And I will email the lawyers directly.
Right. So Judge Bates, before I move on to some of the other panelists, was there an announcement that you wanted to make to the attorneys who were having some difficulties scheduling motions and pleadings and you wanted to address their concerns?
So I got an email from the Consumer Debt Bar Association advising me that people were having difficulty scheduling cases in the courtrooms in Markham on Wednesdays. I was already aware of that problem because some of you may note that your affidavits of service are not showing up on the system for weeks. I discovered this issue a couple of months ago and convened a meeting with the IT department from the Circuit Court of Cook County, the Sheriff's Office, and the Clerk's Office. We have discovered that there is a glitch in the Tyler system. It is slowly but surely resolving itself. I am told as of this morning that it is now limited to the 6th district. I do not know if that is true and that it's only 2 courtrooms in the 6th district, mine and 208. I am going to screen share a flyer. If you practice out here, you need to take a picture of this flyer. If you cannot get your cases scheduled, and I'm not talking about the IDIOT, you can't get it scheduled. I'm talking about meaning user error. I'm talking about you know the process and it's not giving you the date. You need to reach out to Tariah Clay. Her phone number is there. Don't call the general number for the clerk's office. They don't answer it. The box is full. I would email her. She has helped several law firms get their cases scheduled. She will hate that I did this, but we're here to serve the public.
Judge Bates, thank you so much. Judge Sayre, thank you for joining us today. Judge Sayre, what type of rooms or room do you currently preside over?
Currently, I preside over high volume demolition, conservation, building code violations, new construction, and administrative review.
In
case.
the past, what other type of high volume calls have you presided over?
Evictions, consumer debt, and small claims. So those are the cases that I had the room that Judge Bates had before
Yes, he
that
had
he was.
mentioned that.
Mm-hmm.
So you've presided over and you currently preside over a lot of high volume calls.
Mm-hmm.
Have the calls been in person, remote, hybrid, or a variety of those depending on what type
All
of
three.
call?
All three.
Okay. So Judge Sayer, on those high volume days, there's often prove up scheduled, correct? So possibly in an eviction or consumer debt and other types of cases.
Mm-hmm.
Is it essential to the efficient and accurate running of a high volume courtroom that the attorneys provide their prove up packets and their documents in advance for you to review or judge?
Absolutely. Absolutely. Nothing slows down a high volume call more than the judge having to read or look at prove up packets or motions during the call.
And do you also find that it's essential in case a judge might have a question, maybe about a particular type of service, maybe a 5-day notice or something in that regard, so that it can be addressed right at the beginning of a case until rather than down the road?
Mm-hmm. Absolutely.
Judge Sayer, professionalism can be somewhat challenging for all of us, even the judges, when there's not a lot of time per case. And many of these high volume courtrooms, the judges preside over a variety of cases, and it's not just they might have one particular day a week for or an afternoon for a certain type of case. Why do you believe professionalism and civility is especially important on a high volume day?
Basically, the lack thereof can really slow a courtroom down, a court call down. I've got a list of, tips, so to speak,
Please.
as far as professionalism. And, Judge Stein said the first one, and that's be prepared, know the details of your case, because if you have to look something up to answer my question, it just slows down the call. Be on time. That's critical. If you can't be on time, communicate. If you have to be in several courtrooms at a time, if you let the judge know or let the clerk know, we can pass your case. And that tends to, speed things up. Be on time. Otherwise, be courteous and respectful, especially to the clerks, because your case can be called last if you are not nice to the clerks. I mean, it's just simple math. And some of these are very obvious. But I feel like in the days of Zoom, people got very lax. And so they'll be sitting on a call waiting for their call to be heard and not be paying attention. So, they'll be on their phone or reading or something. If the judge has to call your case 3 times, it slows down the call. So that's critical. Pay attention. Plan on a few hours. These calls, we try to get attorneys out quickly. However, there are times where there are many attorneys or interpreters have to be prioritized. And so that can slow down the call. And if the lawyer's impatient because they plan to be in court for 15 minutes, that's just not going to work. So it's very important to, plan adequate amounts of time.
Thank you. Finally, Judge Sayer, as judges, we obviously have to maintain professionalism on high volume days as well. What are some of the things that you do so that you can be ready and as professional and feel as good as you can on those days?
Well, as some of the other judges indicated, I try to be prepared, first and foremost. I'm known as somewhat of a kind judge, but I don't let people ramble. I will cut people off and interrupt them to get to the crux of whatever it is we need to get to often on a high volume call. I try to make sure I'm well organized. I ask attorneys to identify themselves as attorneys. So for example, if I saw David Gordon, he's got his law firm name there. But I might not be familiar with the law firm. If it's a smaller firm or you're new in front of a judge, put attorney David Gordon, for example.
Thank you. And we understand as judges that the attorneys on many of these high volume calls, you might have a new judge who's not done that room before, might be sitting in. There might be a clerk shortage that day. There might be one clerk in a courtroom where there's supposed to be three. So you might not be getting responses from the clerk as needed. But I do make the point to tell everyone, and I believe the other judges do, I'm sorry if my clerk is unable to communicate today. We will make sure that everyone who's here will know what happened with their case, and we will look up every case, even if, it's 2 hours from now. It's just sort of the nature of the beast. Thank you so much, Judge Sayer. Judge Allegretti.
Before you go to Allegretti, I want to add one quick thing I forgot to mention. In a high volume courtroom, when you're submitting paper courtesy copies for briefs and oral arguments, it's really important that the attorneys submit a cover letter, and that cover letter needs to state the date and time of the hearing. If there's no cover letter, then my clerks or my courtroom coordinator need to look things up. And when there's so many things that are happening, we don't have time to look things up. If you're giving us a cover letter without a date and time for the hearing, you're really just wasting our time. You gotta tell us when it is. That's helpful.
Thank you. That is really helpful. And I will say, I know there's some attorneys who, and I find this very, very helpful to me on the eviction call. If there's a lot of documents and maybe there's the bylaws from the condominium association, they'll tab, the section where it says attorney's fees are recoverable, or they'll put little tabs if it's not referenced in their motion. So we greatly appreciate that as well.
Yeah, whatever you can do to make the lives of the judges easier when we have so many cases, are much appreciated.
Yes, thank you. And I like this, and I'm sure the other judges, I've had many attorneys appear after, especially when they're new for a firm. Judge, what do you consider routine? And we'll explain agreed orders that you don't think we need to go over, requests for aliases, dismissals, any of those we don't call on a high volume day because there's just too many, but we will call them if you need us to, and if there's parties here. Judge Allegretti, where do you sit and what type of cases do you hear?
I sit in Skokie room 204, and that's a civil room. It's a mixed civil call. I've got bench, jury, torts, contracts, administrative review, collections, and evictions. And the high volume rooms, the high volume calls are the post-judgment, which I do on Thursdays, and evictions, which I do on Friday mornings. Evictions, a typical call will be anywhere from 40 to 80. A really heavy call gets up around 90 or 100. And what I do on the eviction call, because it's so heavy, I start at 8:30, and between 8:30 and 9, I do all agreed orders and anything where you only need one party. So we can get a lot of the people out of there, a lot of the cases called in that first half hour. And I tell everybody, if you'll get there by 8:30, I'll have you out of there in 2 minutes. Just pop on and you're gone. You don't have to wait around maybe an hour to get your case called. So if that's all you need, come on early and we'll get you out nice and fast. As far as the evictions, I do not try cases anymore on the eviction call. We used to, but after COVID and with the advent of the ERP call, the calls essentially doubled and it got too big to do it. So all eviction trials are on Thursday afternoon, live in person. I do not do them on Zoom. And I do them live in person for a couple of reasons. Probably the biggest reason is if everybody's there, the first thing that happens is they walk out in the hall and probably 90 or 95% of those cases get settled. So They
Thank
come
you.
in, they talk, and they come in and they've got an agreed order. As far as the rest of the cases and when I hear them, anything else for trials or motions, I set them either at 10 or 1:30 on Tuesdays, Wednesdays, or Thursdays. So if you've got a contested matter, that's when it'll be. Juries, I set for Monday morning, and we start them at 9 o'clock. We do a final pretrial where we do jury instructions and motions in limine. Usually that jury won't start until Tuesday morning because the criminal calls here get first dibs on all the jurors. So it's the exception if I've got jurors on Monday. If we do, we would start. If we don't, then we'll start 10 o'clock on Tuesday morning.
Judge Allegretti,
yeah.
just so I can confirm and clarify, on Fridays between 8:30 and 9, that's when you do your agreed orders on eviction cases.
Right. Agreeds, aliases, anything we only need one party. If you come in that morning, you can be out in 2 minutes. I don't do that on any other day during the week. It just doesn't work out that way.
And the eviction is your highest volume court call.
That and the post judgment, those are both high. The other days they can be high. You can have 60 or 70 or 80 cases, but if the orders are in as they're supposed to be, if I've got the orders in advance, I break them down by the attorneys, and we run right through them one after another, and you can get through a lot. Additionally, in my room, which it sounds like a little different than some of the others, I have a stellar clerk, and my clerk is a big help to both me and the attorneys. So the attorneys will by and large check in with her via Zoom, and she'll tell me, I ask her what's next, Bogda, and she tells me who to call. So I'll start on maybe an attorney with a bunch of cases. I'll grab their cases, I'll run through them. I'm done with those, what's next? And I run through those. I agree with what Elan said. When you send us these motions, tab them, have a cover letter that tells me when it's up, what it contained, when it's going to be heard. I got 600 pages the other day, not tabbed, just rubber banded together, not broken down into anything. Literally 600, maybe 650. It was more than a ream of paper for a complex motion. And when they came in, it was set for live in person. I leaned over the bench and I dropped it on the counter, and I said, "Don't ever do this to me again. You need a new date. Bring these in properly tabbed, properly set out. I can't page through these, try and figure out what motion you've got. You know, it should have a couple of things: a cover letter, it should have an exhibit list, and the exhibits should be tabbed along with everything you've got in there."
Thank you so much. Thank you, Judge.
Sure. The rest of what I've got, it's a mix of hybrid and civil. Hybrid and in person. A lot of the eviction is in person. And when I start the eviction call, I tell everybody about the early resolution program. If they're the first time there, I tell them to have their phone number ready. I tell them how to deliver it, and I tell them to have their email address ready. I don't send them out because so many of them are there. I just do it right there. So I don't send mine out to the ERP orders. The ERP people. So they're there primarily if they can add something to the case that's already up. But otherwise, we do most of it in person. And I tell all those people what to do. I give them a piece of paper, go down to the clerk's office, file your appearance, tell them you need a 298 petition. If you don't have any money, virtually all of them are applicable for a 298 petition. And then when they come back, I know what they've been told. So it helps me as we go down the call. And I set my 298 call roughly 4 weeks out, sometimes 5, but usually 4. depending on what 4 weeks out is.
Thank you. So I'm going to move on to some questions for some of the attorneys. Unless, did you want to add anything further, Judge Allegretti?
I think we covered it. If anybody's got a question, I'll happily answer it.
Thank you so much. All right, so we have two attorneys present on the panel, and we greatly thank them for assisting us in the preparation and participation of the CLE. Mr. Gordon, starting with David Gordon, and I'm going to alternate some questions between you and Miss Dido. I know that in your opening, you relayed to us the types of high volume caseloads you appear on. A lot of people might not know this, and I think this is interesting. How many states and jurisdictions does your firm Blitt and Gaines appear in?
Sure, we practice in 9 different states. I focus my efforts in the state of Illinois. I'm also licensed in Iowa, but I don't actively practice there. And I do have some attorneys that are in the audience today that might be covering some of the other states. In each of the states, we cover it from top to bottom, north to south, east to west. So every jurisdiction within a state.
Mr. Gordon, you appear on very high volume calls. What types of things do you do in order to prepare before the call that you have found helpful?
You know what? What I'm following up with what Judge Sayre spoke about being
Please.
professional. And what that means is I need to first understand which courtroom I'm in and what the expectations are. I need to look at the volume of cases that I have assigned for a particular court call and understand and organize my schedule so that I can review, prepare, and submit orders in advance as expected by that courtroom staff for each of those venues. And I'm usually looking this week for what I need to do next week. I want to be able to remind a judge there should be no expectation on the part of the attorneys that the judge is going to remember any particular file. So I need to be prepared to discuss the procedural posture of every case that I have up, should it be asked, and if it's not asked, at least I have the notes. A consumer a consumer defendant may appear in a case and request relief. And I want to be able to be in a position to recognize whether this is the first time they're asking for that relief or if this is a repeated pattern that's been going on for a period of time, just so that the court can look further into court orders or half sheets on the notes they have. Other things that I find to be very helpful is I want to be able to tell the court the next dates. I anticipate when I'm on a high volume call, certain matters are going to be continued. I'm always surprised when there's an attorney there with multiple files and they don't know what the future date is. Also, the attorneys should listen. If an attorney before you asks for August 1st as a continuance date and the judge says, no, that date is closed, I should not be asking for that date. I should process that and move on to something else. It's always incredible, especially an attorney with one case and they have no idea if they have service or if they do have service, when they have service, and the type of service. These are things that you can plan ahead. If you know that there's matters that are going to have briefing schedules, I jot a note what 4 weeks are out, what 7 weeks are out, and what 8 weeks are out. So I can tell the judge the briefing with this schedule should take us to August 15th. How about we get a hearing date after that? There's an expectation by the court that we're going to be able to be quick and accurate for each case we have. And so that just requires us to prepare in advance. And it's easy to do.
And to follow up on what you said about being in a variety of courtrooms in Cook County, between the Daly Center and 5 other district courthouses, the attorneys and the firms have to manage many different judges, many different personalities, many different standing orders. Sometimes there are no standing orders, different courtroom procedures, different clerks, all of which can change in a rotation, which we know is very challenging. It can be very challenging for the judge, but we know it's very challenging for the attorneys. Have you found ways to manage these situations over the years?
Yes. There's an Illinois Creditors Bar Association. Uh, there are viewers in this audience that are members of the Illinois Creditors Bar Association. That's a very helpful resource with ongoing chats about certain situations in certain rooms or scheduling issues and that sort of things. Also, in our law firm, I have a playbook on every venue that we go to. And so that playbook gives us information about the expectations for each judge. If the judge allows for appearances via Zoom or other means, we keep that information. And then I also have further detail in the playbook, so our clerical staff knows what's expected when they're preparing draft orders for the attorney to review prior to their submission.
Thank you so much. And I'm going to bounce back to you in a few minutes, Mr. Gordon, but I have a couple questions for Attorney Jade Dito, who is here, and we're glad she's here. Ms. Dito, while the court is in session, while court call's running, are there certain things that you're doing while the court call is in session and the judge is not on your cases that you find very helpful and efficient?
So, like David said earlier, I'm listening for calls that are already full and adjusting my own dates accordingly to make sure that when my cases do get called, I already have a new date for the judge. The judge doesn't have to worry about that. The other thing I'm looking for is I'm looking to see who's on the call. Do I have opposing counsel? Do I have pro se defendants? And I make sure that I mark down that those people are on the call. That way, again, the entire time I'm sitting there, I'm preparing for my cases to be called. I'm looking at who's here. I'm looking at what happened at the last date. Is this the first time we're up? Is this the third time we're up? And I'm anticipating not only what I have prepared for, but what could possibly happen. And that includes somebody coming in who hasn't come in before. And another thing that I find really helpful is coordinating with opposing counsel on things like agreed orders, on continuances, on trial dates, that kind of thing.
Thank you so much. Another question, counsel, that I have for you. What practices do you find helpful in interacting with self-represented litigants who may ask you for legal advice or about the best way to proceed? We know that on the high volume calls, there's a very, very large percentage of self-represented litigants. Are there certain practices that you use or that you've learned to use during your time on these calls?
So one of the things that I like to do is I very gently remind them that I'm not their attorney. I represent the person that's suing them. And I very heavily encourage them to avail themselves to any free legal services that their county may have, or for them to look into a legal aid organization. But I really do try to keep that kind of distance to really make sure that those resources that are being used are being used.
Thank you, because I know that can be challenging. And just a jump off, at least in the consumer debt call, and I think this might be helpful to those attorneys who are here that regularly appear on it. Many respondent defendants work with debt settlement companies who might not have an appearance on file. And with that on our particular case in Odyssey, how do you handle those situations where the party is working with a debt settlement company? They're not present on the Zoom, they're not present in the courtroom, but their client is.
So I consider debt settlement companies pseudo attorneys or ghost attorneys. They're there in all but paperwork. So during the call, anything that I say to the defendant is anything that we've already said to the company or has already been agreed to by the company. If the defendant wants to create a settlement, I tell them to work with their debt settlement company and contact us. If they contact me directly, I reroute that through their debt settlement company. And I really encourage pro se defendants to use the people that they've hired. Now, if they decide that they want to work with us directly, I let them know, hey, you can't contact the office. But I'm treat it as an attorney, as I treat it as them having an attorney, but I'm also aware that they're an attorney, but not really.
Thank you so much. Mr. Gordon, another question or two for you, and then we're going to move on to questions for the last 10 minutes or so from the audience. And I see that many of the judges on the panel are answering questions in the chat for specific questions. So thank you for that. Mr. Gordon, how about immediately following the call? So what types of things do you do right after the call for that particular day that you find helpful for when the case is up next time? So you can then obviously move on to the other work that we know you have in other courtrooms.
Okay, so many times after a high volume call, a pre-submitted order is going to have changes.
Yes.
Depending on who the judge is in that courtroom and the particular day and how busy they are, a judge may agree to alter a order, or alternatively, they may say, can you give me a fresh order that conforms with my ruling today? So I am going to go through my list of every case that was called, and I'm going to put a detailed note. And in the event that there's a change order, I'm going to make sure that that change order is prepared conforming to the judge's ruling and have it turned in right away. For the matters, even if a matter is not turned in, I want to have some detailed notes. If an attorney appears for the defendant in the court call, even if they don't have an appearance on file, I try to record their name and the organization that they're with so that we have the opportunity to follow up with them later. If there's a consumer that mentions something about a hardship situation, I'm going to try to record those notes about what they said in open court so that we can share that with our client to the extent that it's not HIPAA related information that I cannot record in our files. So I'm going to have detailed notes, including the future date, the future time, whether I have to give notice to anyone, and whether the order has to be submitted to the court. Those are the general things. And then once I'm done with my job, I pass it on to my clerical staff so that they can update our electronic files as to the what's happening next in the case, just as the Cook County Clerk's Office is doing for the judges who are on this panel.
And I'm going to ask this first to you, Mr. Gordon, and then Ms. Tito, if you could add anything. We've talked about this, but truly on a high volume consumer debt call, do you believe good communication with the courtroom clerks before the call, possibly during the call and after the call, is essential?
Absolutely. I think everyone who's participating today knows that the clerks make everything run smoothly. And if the clerks are on their game, everything runs smoothly. And if there's someone substituting for someone else that's not familiar with the procedures, then we can have a rocky start for a large call.
Right.
And when we have a good rapport with the clerks, they're able to tell the law firms that, hey, there's no attorney in here, and the call started 5 minutes ago, or you submitted 100 orders, but you're missing 5. Here are the case numbers. Or after the call, they may say, one of the orders was damaged. Can you please resend it? All sorts of things happen. So having that open communication and goodwill between us and the staff of the clerk's office is extremely important.
Ms. Tito, did you want to add anything to those points?
I was going to say that the name of like David said, the name of the game here is time optimization. How are we going to make sure everyone's case is heard quickly, completely, and clearly? And one of those things is making sure you have a good rapport with the support staff, making sure if you know that you have to call in ahead of time and say, hey, we're pulling these cases. If during a call they don't have a document, they can tell to you, be like, we need this, and you can get it to them. Having a clear line of communication and being able to work efficiently and quickly with them is exceptionally important, especially for high volume cases where you're looking at like 200, 250 cases, not just you, but like the entire call.
And I, just a side note, Mr. Gordon, Ms. Tito, I regularly appear in front of me, and I know some of the other judges, and They are excellent at time optimization and also professionalism and displaying kindness towards the litigants, most of which have just fallen on very hard times in their lives. And we as judges greatly appreciate that. It helps our courtroom run more efficiently. Thank you. We are going to move on to some questions here in the chat. All right, let me, hold on, where? I know some of them have been answered. So let me see. Anyone? Okay, let me start from the top. Let me see some questions. It looks like there's some questions about the materials, the links, questions to specific judges. Okay. All right, here's one. Well, and I think this might have been answered, but what is the most efficient way for attorneys to signal that they have an agreed order or unopposed order, or that their case will take more time so that the court can manage the call efficiently? That's an excellent question. Do I have any judges? I know Judge Sayer, you answered, ask the clerk to notify the judge. Judge Stein, that's a great answer. Would you like to add to that?
Well, I mean, if I go through the call a week in advance, and I know enough about the motion, so I could tell what is going to be faster and what is going to be slower. I don't call the cases in order in 1501. I call the cases based on speed. So if I know that it's an agreed order, and I could tell that from looking at it, or this is going to be, it's something that's going to take a long time. The ones that take a long time, I call last. So, and it's not, and it's basically just because that's a good way to manage the call. If you, nobody has to sit through a 20-minute argument on a motion to compel. That could be done at the end.
Right.
So basically, get me the stuff in advance. File it the way you're supposed to be doing it according to our standing order. Know what a standing order is, read it, and follow it.
Thank you. And this might have been answered, but I see that Judge Sayer and Judge Bates answered this.
Colleen,
yes.
if I might,
please.
on that point.
Please.
In my courtroom, I do not call every case. I cannot call 600 cases. If I have an agreed order, when the people check in, my clerk tells them, you're free to go. The judge will enter the agreed order. If I tried to call 600 cases, we could not complete that call in an hour and a half. So the attorneys, if you want to get in and out, check in early and tell the clerks what you have. And they'll pull the order. It's already prepped. And so there's, I'm like Judge Stein. I think we all really work hard to be prepared.
Yeah, that's the key, looking at all the orders in advance and having everything organized by firm, name, and agreed. It's very, very difficult. You can't call all the cases, the routines, but if someone is there and would like a routine case called, we will certainly call it.
Tomorrow's eviction call, I can tell you every case where there's service, if there's not service.
Yes, and this is another point real briefly that we had chatted about, the judges, and everyone has just, judges are different, obviously attorneys are different. I know on my high volume call, I do want the type of service that was perfected on the order for two reasons. Number one, the attorney is checking before they're giving the court the order. Yep, we had personal service on this date. Oops, we didn't have service. We need more time. And then the court has jurisdiction. Obviously, that's key. But then we can mention to the respondent, I see that you were served on this day, and it's right there in front of us. So some judges like that, some don't. Obviously, you're going to have to know your judge, and if or ask, stay after. Come on a different day and say, Judge, I'm wondering what your procedure is on this. I'm always happy when lawyers do that. It looks like we have time probably for one more question. This one looks like it was answered. I'm kind of scrolling. Hold on. Anyone see one in here? Hold on, let me see. All right. what is the most efficient way for attorneys to signal that they have an agreed or unopposed order, or their case might take longer so that the court can manage the court call? That is an excellent question. I see that Judge Sayer and Judge Bates both answered that, or Judge Sayer said, ask the clerk to notify the judge. And we know that on these high volume calls, someone might not always be monitoring the chat. Some days it's just too difficult. There might be a staffing shortage. The regular judge might not be in there. And unfortunately, on those days, sometimes the parties have to wait to the very end. Hopefully that's not the case all the time. But we as judges know how trying that can be for the attorneys when that doesn't run perfectly well. Does anyone want to add anything to that last question? Nope.
There's two more questions in the chat.
Can you see them? Because I'm scrolling, and would you mind doing those two so I
Sure.
can see?
One of them says, if a counsel is
there you
being
go.
investigated for legal malpractice, do judges treat such counsels differently during other proceedings and unrelated cases? So
No.
my question would be, how would we know? Like, I'm not aware on a daily basis who is or is not being investigated for legal malpractice. So I treat everyone the same all the time. And I would imagine that most judges treat everyone the same as well, but I'll let the other judges address that.
I agree with Judge Sarah. I mean, we don't sit through
Right.
the court docket, looking for legal malpractice cases. I mean, how would we
No.
know? And so no, I mean, we treat everybody the same.
So
Right,
the one thing I will say is my standing order, I served on the ARDC before I became a judge. My standing order specifically says that when you make a representation to me, you are an officer of the court. It's not answering that question, but just so you, well, it's not, Yolanda, but the reality is people do need to understand that there are consequences for unethical conduct. So I have law firms that repeatedly make representations to me about service, not understanding I check. And so some of those firms now get called on the carpet quite a bit about their service. I'm never going to give a default judgment without talking to the lawyer.
Thank you. Judge Sayer, it looks like there's one more question. I see it now. It's specific to landlord-tenant law, but I'll ask this and then we'll move on to our closing statement. Where the landlord does not want the tenant and the tenant has no defense, there should be a fast track. I'm not sure, that might be a statement more than a question. My response to be, we have the ERP order. There are exceptions to cases that are not eligible for ERP. I know over in the 3rd district, we have 3 courtrooms. We give a 1-week date. We try to move things through. Those cases that involve homeowners associations through the new ERP order are supposed to go directly to a trial courtroom. I know the clerk's office and the Supreme Court have been working on those codes. I am told it's right there, that it should be very soon. Did anyone else want to make any comments on that question comment that was in there? I don't think we need to. Okay. Well, I wanted very much on behalf of my colleagues and the attorneys on the panel to thank the Decalogue and Aviva for allowing us to present this. Thank you very much to the panel of judges and attorneys, as well as all of you who've attended today. We know your time is valuable. We all learn from one another. Judges learn from attorneys, attorneys learn from judges. Every day we learn, and we should all be continual students of the law. Also, please take care of yourselves and each other. The Lawyers Assistance Program is going to be coming out very soon with the result of their survey about the stressors and the large volume of stress that those in the legal profession are under, and what a large percentage compared to other populations. And we know that the practice of law is one of the most demanding and stressful careers. So please, obviously your physical and mental health is crucial. Please take care of each other and yourselves. And thank you very much for your professionalism and appearing today on this CLE.
Thank you all.